Welcome back. We continue the conversation. Coming to you, Dr. Maxwell, from what Willis has mentioned, 149 talks about the voting of the nomination, while 137 talks about the vetting of the candidate. Do you see it the same way?
I think I should insist that contextualist reading of the Constitution is far better than a textualist reading. I do agree with my colleague, of course, my senior, that, of course, you cannot read any provision of the Constitution in isolation. You must read, in the dictum of Tinyefuza by the Republic, the provisions of the Constitution in a way that one sustains the other and does not destroy the other. And this is exactly what I'm talking about. If we had to read Article 137 in such a way that it sustains, or does not destroy Article 149, this is what it would mean. That there has to be a distinction, and a clear one, between election into office and the filling of a vacancy, okay? So that one does not apply the requirements of a candidate when it's election time to the provision of the Constitution that governs the filling of a position, especially when that discretion is conferred on the president. Now, election regime actually should be different and differentiated from a vacancy regime. That is what I call as a contextualist interpretation of the Constitution, such that these provisions sustain each other. If the Constitution intended that there was to be any entity, EACC, by the way, in fact, before we come to IEBC, before anybody is nominated and vetted by the IEBC in election time, there is the EACC involved, there's the Higher Education Loans Board involved, there is the DCI involved, and all these background checks and certification that one needs to present to the IEBC, then IEBC approves, then nominates. In fact, that is Article 88 role of the IEBC. Such is not to be found in Article 149. You see, you cannot jump the gun. If election requires all these certification and clearances before you go to the position, before you go to the IEBC, why are we only insisting on IEBC when it comes to the filling of a vacancy? If one was to interpret the Constitution, it will be a negation of actually the powers conferred on the president. In fact, we should read Article 149 as what we traditionally call in constitutional law as a prerogative of the president. Filling a vacancy, the president has a right to choose anybody to become the deputy president as long as he meets the criteria. Okay? And those criteria you'll find in the national governance, the principles of national governance and leadership. You'll find them in the leadership and integrity. Okay?
Yeah.
Of course, without negating the Article 137 requirements of a person who should be president or deputy president. I am emphasizing the point that constitutional interpretation, okay, should not be made to be so ambiguous and should not be complicated and obfuscated by requirements that cannot even be infused into the reading. What my colleague is actually doing is what we call in constitutional law as reading into the provision of the Constitution. The concept or the idea or the notion of reading in only applies to legislation. And you know very well that legislation or a regulation is always very inferior to the Constitution. Judges cannot be permitted to read into a provision.
Okay.
Okay? So I do not see the requirement, the involvement of the IEBC. If they indeed have to be involved, then you have to start from the very beginning. DCI, HELB, all these approval bodies.
Okay.
Which is not in Article 149. If it is, then he should point to us. And I think he's also splitting hairs. The vetting and the voting. Okay?
Yes.
Article 49, when it talks about voting, unless the language is so ambiguous, the intent, the purpose, and the purport, which we call purposive reading of the Constitution, they do not just vote and then they sit on the vote. The vote has the purpose and the objective of approval Okay? And one should actually not just go and vote because it is Kindiki or it is Rigathi Gachagua or Maxwell Miao. No, it is expected that, like any other person, when you are voting, you're exercising your conscience, you are exercising objective judgment. And the objective judgment will look into all those considerations that he's perhaps talking about. IEBC does not just vet. They vet to ensure that one meets the constitutional requirements. For example, even the moral rectitude that the Constitution requires under the Leadership and Integrity Act, under the provision of the Constitution. So that Parliament is now conferred the role, in context, the role of what any other agency should do in the circumstances when a vacancy arises.
Okay, I want us to move on from this issue, but I know Willis wants to rebuttal. Even as we do, I just want to prepare my team to just give us that soundbite of the Senator Okiya Omtata, but your final remarks on this IEBC issue.
Let me say this. You know, my colleague is struggling with reading the Constitution. I heard him talk about, in fact, how he explains it. This will be a very good argument during the Moi days, where the Constitution always deferred to the President, or the law deferred to the President. We are now in 2024. And we have a 2010 Constitution. And one thing that he misses by a mile is to say that in terms of criteria, the qualifications, you'll find them in Article 10. Article 10 of the Constitution is merely prescriptive of the national values and principles of governance. It does not set anywhere the qualifications of a deputy president. Then let's go further. When he says that the work of Parliament is to vote and to approve, when it comes to the question of elections in this country, where a vote is involved, that you are going to process a nominee to a public office.
Yes.
Article 88 vests that responsibility on the IEBC. So, in terms of Parliament, National Assembly, voting on the nomination, on the nominee, you presume that that nominee must have met the minimum criteria before his name is forwarded. And where do we find that minimum criteria? And the criteria is to make sure that by the time you are holding office, this applies to you in office if you succeed. One of them, they are found in Article 137. One of them, you must be a citizen of Kenya. You must not owe allegiance to a foreign country. You must be a university degree holder. All those qualifications. And the things he's referring to, I must make it very clear here, as a former prospective presidential deputy president running mate. HELB, DCI, they have no role. The qualifications are those which are found in 137.
Okay, but law is subject to interpretation,
yes, and
right?
those qualifications, in my view, applies to you because it means that by the time you sit there as a deputy president, we will know what is your minimum qualification. Yes, you're a citizen, you're not a Ugandan. You belong to a political party. You subscribe to the code of conduct. All those qualifications in 137 are with you when you sit in that office. But the route that my colleague is suggesting means that if you leave it to what he calls the unfettered, we are trying to fetter the discretion of the president, then is it trying by implication to say that the president can nominate a Ugandan to go and take the name to Parliament, and Parliament votes for it because he's the one who did the vetting? That vetting is done by an independent body. That the question of eligibility is a question that vests in IEBC. And to his credit, William Ruto, in attempting to meet that, went to IEBC, as he presumed it exists, and he got a clearance letter from Marjan, clearing that Kithure Kindiki meets the minimum qualifications. All that I'm adding to the conversation is to say this. To the extent that you went to IEBC, which IEBC did you go to? Because according to our laws, according to the interpretation of the laws that the courts have given, including the Supreme Court, IEBC is only properly constituted and to be able to perform its functions when there's a chairperson and commissioners.
All right. So, of course, the courts will rule on that. And, of course, we'll continue with this discussion on the IEBC because you each have different opinions on that. But the former Deputy President, Rigathi Gachagua, is hoping that the courts will save him, giving a political lifeline. I just want us to listen to what Senator Okiya Omtata said during this particular process.
To remove the Deputy President The provisions of Article 144 and 145 relating to the removal of the president, the deputy president, of the president shall apply with the necessary modifications to the removal of the deputy president. The Constitution does not anticipate a situation whereby we apply Article 145 on the removal of the deputy president without modifying it. The phrase is, shall apply with necessary modifications. What modifications has this House made, or the National Assembly made, or Parliament as a collective made to Article 145 before applying it to the Deputy President? Can we impeach the Deputy President using the standard for impeaching the President when we know very well that the President is immune to prosecution, and therefore the certain standards that apply to him won't apply to the Deputy President? So given that the Deputy President has not enjoyed those immunities, how are we protecting him? How are we ensuring that this process is constitutional? It's my submission there's a total failure on Parliament to have proceeded to impeach the Deputy President without making the necessary modifications to Article 145. And you have seen the potholes we have fallen into. It's okay for the President because the President is immune from judicial processes. But is it okay that the Deputy President should be prosecuted using the same standard used for the President?
So he argues that that particular process, the entire process, is flawed because there's need to make modification of Article 145. Is that the case? Let's start with that.
I think Okeya Mtata's reading of the Constitution is a layman's language, it's a layman's interpretation. The word modifications, I think, has also been used there in context. So it's a word that requires only interpretation and not application. In this sense, the Constitution requires that, the Constitution anticipates that the office of the President is different from the office of the Deputy President. So that when you are applying those two provisions, Article 144 and Article 145, you contextualize it in your own interpretation, knowing that this person is the Deputy President, but the circumstances, the requirement, the provisions, the meanings should apply only when the situations may be necessary. It does not envisage the lessening of standards, the dilution of standards just merely because this person is sitting in the office of the Deputy President. It does not anticipate different standards. It does not anticipate different requirements for removal of the office of the President. In fact, the grounds for removal, if you read the provision governing the removal from office of the Deputy President, Article 150, reiterates those that are provided in Article 145, which of course is gross misconduct, the breach of national or international law, or the breach of the Constitution. Those are the three tripartite requirements for removal from office of the President. It is not anticipated that when you are interpreting those standards, you will modify them to fit the office of the President in such a way that you will lessen the standards, or you lessen the requirements, or you lessen the tests that need to be met. So I think Okeya Mtata's, of course, that's a political language that he was using in the House, perhaps to dissuade the House to perhaps insist on probably not higher standards because the office of the Deputy President is far below that of the President. No. The constitutional requirement, those tripartite requirements, can only be applied actually to the hilt and to the teeth. Okay? So the political interpretation should not actually infiltrate the constitutional interpretation. If I was the National Assembly, and I think that's why in one way or another, I think the process yesterday by the National Assembly was actually a political process. Only today, then, they became aware and alert to the constitutional standards, the constitutional requirements that they tried to adhere to. And I think that's why Deputy President Rigathi Gachagua has beaten them to their own game. The constitutional requirements, needed to have been proved For example, if one breached the Constitution in one way or another, that ought to have been tested before the Senate, before the National Assembly, and that you give the Deputy President a chance to defend himself.
Okay.
Okay? So the fact that the Deputy President, in the same way as the President, ought to be given a chance to defend itself, that cannot be read with any necessary modifications. Okay?
Okay.
It's a constitutional standard that has to be adhered to.
Okay. Willis, coming to you, staying with what happened yesterday, that issue of asking for an adjournment of that particular sitting to Saturday, and many Kenyans are asking, what was the rush? Perhaps maybe you can explain, would the Senate have suffered any prejudice by adjourning that particular sitting?
Let me say this. The Senate, if you look at how it conducted itself, it misunderstood the law. Because what the provisions of Article 149 require is that the National Assembly submits a name within 2 days. I mean the motion within 2 days. They submitted their instruments of impeachment within the 2 days. Then it provides that the Senate can form a special committee to conduct investigations. The investigations must be concluded within 10 days. So what ought to have happened in the 10 days was investigations.
Not the entire process?
Not the entire process. Then, once the investigations are complete, they are supposed to now prepare a report. That report makes a recommendation. If it makes a recommendation that no impeachment, it ends there. If it makes a recommendation that you impeach, then you table the report before the whole Senate. And the Senate will require, again in Article 149(6), will require the Deputy President to appear before it. And he has a right, the wording of the Constitution, he will have a right to be heard and to be represented. So what ought to have happened in the 10 days was purely a question of conducting the investigations. The Senate, when they moved the motion of a special committee, they adopted to take the route of converting the entire Senate into an investigations committee. So if they had understood their role and drew every stage of this process, they would have known that the 10 days referred to applied to investigations. The Constitution has not told them which timeline within which the report must be voted. So there will have been no prejudice, there will have been no constitutional crisis, if any, if the Senate extended by a day, as suggested by the Speaker, to reconvene on Saturday to hear the Deputy President. Or even the following week, or even after 2 weeks. Because there is no timeline given to them when to vote on the report of the investigations.
So how far would they be able to stretch it?
So, I mean, and then go back. I want to take you back, to answer that. I want to take you back to certain rights that were being infringed in this particular instance. In Article 25 of our Constitution, we have what we call absolute rights. They are absolute. You can never take them away. And they are largely on the person too. The right to be heard, fair hearing, and habeas corpus. You cannot infringe. These are called, in fact, I normally refer to them as, these are superior rights, even to the Constitution.
Okay.
Because the Constitution has elevated them and said they can never at any given time be infringed. Now, if the Senate is saying, we have an administrative timeline here, which they've misinterpreted in the first place, that tells us we must conclude within 10 days, they must ask themselves, but what happens to his Article 50 right to be heard, which is an absolute right under Article 25. We must give the opportunity so that even if this matter went to court, the Senate will have a strong argument to say the timelines were going to conflict with his right to be heard because nobody can predict illness. And the fact that he was ill, that's a very valid reason. If somebody is sick, you cannot proceed without him. You cannot force a sick person to attend to hearings.
Okay.
Many a times, in fact, they always say that the easiest way to get an adjournment in court, that even your colleagues don't oppose as an advocate, is when you or your witnesses are sick. Because it is accepted. And then the opportunity will come. So the only thing Gachagua will have benefited is maybe just kick the can down the road for another extra 1 or 2 days. But his day with destiny, it was predetermined. He was going to go. And even now, as we are going through these legal questions and discussions, Gachagua's day with destiny is here. is just stretched it a little. He will still be voted out by the same Senate, because don't think that these people were giving him, in terms of trying to even pay attention to the evidence and the reasons why they want to impeach him. That was a political question. All that we are saying, me I'm saying in particular, is that in pursuing your political objectives, please adhere to the Constitution. Follow the law at any given time.
Okay.
And that is important because of this,
Okay.
as I conclude. It's important that when all else fails in the political sphere, when people are pursuing their personal interests in politics, our only anchor becomes the rule of law. And the law guarantees everybody a predictable future and certainty as to what needs to be done.
Okay, coming to you, and let me take you back to Wednesday when we saw that three-judge bench rule on the issue of separation of powers and the doctrine of separation of powers. So in this particular process, it is a political process. So who is in whose business?
I think one important thing that really needs to be understood is that the impeachment process is an administrative process because it determines the right of an individual. So that when the Senate or the National Assembly sits to impeach a person, it's an administrative process that the court can intervene on. The argument that the court cannot interfere with the political process is not viable. It has no constitutional basis. All that one needs to demonstrate when they go before a court is that an institution that either sits as a disciplinary body or as an impeaching body, which of course it involves the removal from office, and the process itself has affected my rights in one way or another. So I think Gachagua was right to go before the court and complain about, in one way or another, the violation of one right or the other. So that the court refusing to grant an order does not mean that the court is actually keeping away from highly politically volatile decisions. The High Court was just saying perhaps that you have not demonstrated any individual right that has been infringed in one way or another. And I think Gachagua must have gone and reflected very, very deeply that if I was not able to demonstrate this right, and I think the Senate should also have thought about this very, very deeply. So they resorted to a political process and a constitutional process. And look, Gachagua actually beaten them. And probably this war, this contest and contestation probably will be with us for at least 1 year. For the very, very simple reason, they did not accord Gachagua a right to be heard. That right cannot be limited under the Constitution. I think it was premature for Gachagua to go to court before the National Assembly even started the impeachment process, because at that time he was not able to demonstrate any right that was violated. Here in this particular case, Gachagua can actually demonstrate the Article 145 5 infringement,
Yes.
where he has not been heard. And indeed, the rush by the Senate to conclude the impeachment process did not properly reflect on the constitutional requirements. The Senate, of course, has got very honorable professors of law, Professor Jenda and the rest. They ought to have read the Constitution such that, in such a way that they could not have given Rigathi Gachagua a lifeline. Actually, they have given Rigathi Gachagua a lifeline. The National Assembly today tried by ensuring that the voting process is transparent. You know, the people can see what the National Assembly is doing, who voted for what. In fact, the entire House voted in favor of Kithure Kindiki. But that is only after censure and warning from Otiende Amolo. How is it that the Senate missed such a critical process, such a critical constitutional test, critical constitutional requirement of having somebody to be heard? And I can tell you for certain that Rigathi Gachagua probably will have the last laugh. He may have the light of day, for the reason that not having been heard is a violation by the Senate. The Senate, of course, one would want to say separation of powers, the executive on this side, the Senate, the Parliament and the Judiciary. it is a critical constitutional question that when you are sitting in to remove somebody from office, you are sitting there as an administrative body. They are not sitting there as a legislative body or as an oversight body or as a representative body. They are actually taking an administrative action that affects the rights and interests of an individual. Where such happens, the law requires that you must accord somebody the due process that will be required even in court.
All right. We're out of time, gentlemen, but briefly, in 30 seconds each. And Willis, even as you give your final remarks, many are saying this is a constitutional lacuna, is it? And if so, what happens in the case?
In my view, there's no constitutional lacuna here.
Okay.
The political hotheads are just trying to throw so many words and interpretations and to come up, in a way, just muddy up the conversation. What to me is a very clear process. The courts are seized of this matter. The courts have issued orders. The courts are there to interpret. I mean, what else are we spending so much energy saying, oh, we'll swear him in, we'll do this? Just go to court. Let the court decide. And these arguments that you are calling constitutional crises, they'll be made in court, I believe.
Okay.
And the courts will issue an order, and life will continue. The crisis that exists is a political crisis of somebody who maybe hoped to reconstitute his executive in a way that he wanted by a particular date. That's the crisis of leaders, not a crisis of the people of Kenya. The people of Kenya care about Adani, SHIF, SHA, JSS, the universal healthcare workers who have not been paid 6 years, are not earning half their salary, they are not even getting that. And these are the people who are the frontline workers in terms of saving the lives of Kenyans. So me, I don't believe we have a constitutional crisis.
30 seconds.
I think as we speak, we have no person sitting in the office of the deputy president. Rigathi Gachagua has been impeached. So he's not the deputy president. What the courts have stopped is the appointment of a new deputy president. There is a vacancy in the office of the in the office of a deputy president. But I think going forward, of course, this is now political speak, anybody who will sit in that office going forward from the time when the new deputy president has been appointed, one thing that they really have to deeply internalize is the question of making critical alliances in politics. Don't attack the executive as a lone ranger.
Okay.
That's what the Deputy President Rigathi Gachagua did.
All right, thank you so
alliances.
much, gentlemen, for making time to just come and share your nuggets of wisdom with us in regards to matters law. Of course, you know, law, as they say, is subject to interpretation. Willis Otieno, advocate, and Dr. Maxwell Miawa, scholar and advocate. We take a break. We'll be back with a few stories.